Hello, everyone, and welcome to Uncivil Law. Hope everyone's having a great day. For today's story, we are going to do one of the updates on the Hailey Paige case. This is JLM Couture versus Hailey Paige. This is Hailey Paige's answer and counterclaims. So we're going to read this, and we're going to discuss what it says. We're going to go through it in some depth and try to analyze what we think so far. So far in our journey, for those of you who may not have seen what came before, JLM is a company that does fashion. And Hailey Paige was hired to do fashion, principally related to wedding dresses. And JLM probably got access to her name and access to intellectual property of hers from their contract. And so we've so far tentatively scored this in favor of JLM based on the arguments. Hailey Paige had some better arguments, it seemed to me, that weren't made, but we can only score it based on the arguments. So we're going to read her answer, which is her formal statement as to what she thinks is true. And then we'll also read any counterclaims, so she wants to make some accusations of her own. So that's what today's event about, so let's get started with that. So the first thing that we just take note here is just the standard stuff, right? So this is the answer, right? So this is saying what is or is not true from their perspective. So they either have to admit it, deny it, or say it's no response is required based on it. So you can see here, like for jurisdiction and venue, they admit the court has subject matter jurisdiction, but otherwise denies the allegation. Paragraph 3, she admits venue. Paragraph 4, she admits venue. And paragraph 5, she denies any complaint. So she's happy with this court hearing the case. So we won't see any 12B2 motions for want of jurisdiction or 12B3 for want of venue. But otherwise, she's going to deny the facts that they allege. So she says she did, and then she goes, I'll just spoil it for you. She denies everything. There's no admission in fact. So she just goes through this and just denies everything. She doesn't want to admit to any of the things that JLM said, which from a purely tactical standpoint, I'm not sure is wise. It might be better to admit to some things and deny the rest, because denying everything can be a problem. But so she just uniformly denies all the facts, and she denies all the allegations relating to the various counts. So it's just a lot of pages of that, right? So we'll skip all that because it's just denial upon denial, and we'll cover the affirmative defenses and counterclaims. Okay, so here are the affirmative defenses she has. First affirmative defense, JLM's claim for relief are barred in whole or part for failure to state a claim, so 12B6. Second affirmative defense, JLM's claim or relief are barred in whole or part by terms of the contract. So the contract breaks in my favor, not their favor. Third affirmative defense, the agreement is ambiguous. And because it's ambiguous, it should be construed strictly against its drafter, which is a correct statement of the law. Well, it may or may not be a correct statement of the law. Let me back myself up. If this were a contract of adhesion, that would be correct. So if one side writes the contract and the other side is to take it or leave it, then construing it against the drafter is totally the correct thing. So it would depend how much influence Hailey had in the contract in terms of negotiation. So JLM may have written the contract to start, but if Hailey Paige had substantial hand in negotiation and was able to influence the language, then this might not be correct. So if it were wholly one side that drafted it, yeah, you'd interpret the contract against them. But if it's more of an even negotiation, you wouldn't necessarily interpret it against anyone biased. So it depends how much influence Hailey had, as a matter of fact, during the negotiation process. And it appears she had some. And it seems like she had some clauses that were changed for her. So it appears this wasn't strict take it or leave it based on what we can tell right now. But how much that will change the end analysis is still unclear. Fourth affirmative defense, the claims for relief are barred in whole or part by its own material breaches. So because it has breached the agreement, it can't claim. It doesn't have clean hands. Fifth affirmative claim, the relief are barred in part because the contract or its agreements are terminated or void because JLM failed to satisfy or perform conditions. No, that would be a very, very unlikely thing to happen. If JLM fails to perform, it doesn't void the agreement. It gives you basis to do it. Now you can try this and say, well, they did such bad things that makes it voidable, so I have an option to make it voidable, but that's a hard trigger to pull. So you wouldn't really expect that except in some really extreme circumstances. So that seems very unlikely here. The claims are barred in whole or part by doctrine of trademark acquiescence. So the idea is that I've been using your trademark against you and you haven't cared, so you can't get to me now. Claims for relief are based on equitable doctrine of latches, estoppel, or unclean hands. Unclean hands, maybe. Latches or estoppel, no. These claims do not seem like they've been unduly kept from happening. They're barred from doctrine of waiver. JLM didn't care about certain things. Well, to the extent they didn't care and were waived, they can't go back on that. So if something was waived, they can't go backwards, but that doesn't mean they can't go forwards. JLM has not acted in good faith. JLM's claims for relief are barred because not suffered any damages, and JLM is barred from asserting any cause of action. JLM's relief are barred because it's failed to and neglected to mitigate damages. So if there's an ability to mitigate, you have a duty to mitigate. That's absolutely true in contract. Now, again, that wouldn't bar your claim for relief, but it would bar the amount of damages that you could get. So if you can mitigate your damages, you have to. You can't exasperate your damages. So, to give an example, suppose that you have a contract with someone to supply you lumber and they don't come through. Is it possible for you to buy lumber from someone else? Then you should, because that would be, now it's more expensive. So they'll certainly have to pay the difference, right? Because assuming they're in breach, they'll have to pay the difference. So you'll get the compensation, but you have a duty to mitigate. So you don't unnecessarily, pool the damages. Suppose you're a contractor building a building, and for every day you're late, you get fined $1 million. I don't know. And suppose there's $10,000 worth of lumber that's not being delivered. You can't just sit on that and let day after day after day accumulate. Even if the replacement lumber is $30,000, that's better than the $1 million fine, right? So yeah, you have a duty to buy the lumber at $30,000, then sue them for the difference. You can't just sit on it. Is basically what that's talking about. But that would only prevent you from getting the difference. You still be, so if you had that example where they didn't buy the lumber, then you say, well, what could you have bought the lumber for? $30,000. Okay, you still have to pay the $20,000, and that's all your damages. Even though you've paid millions and millions of dollars, that's on you. So that's about it. 12th affirmative defense, principles of offset or set off. So the idea is that, I have damages that I'm going to get money for, so our damages are offset, like offsetting penalties. 13th defense, JLM has been unjustly enriched. So they didn't have a right to do something, and they did it, and they got money as a result, and I should be having that money. Doesn't seem plausible based on what we see so far, but okay. And any additional offenses. Some other stuff, which maybe, we'll figure out later. All right. So we have some counterclaims relating from Hailey against JLM. And one of these counterclaims deals with sexual harassment in the workplace. So I thought it'd be helpful to discuss the standards that relate to sexual harassment in the workplace, at least under U.S. law. This might change under state-specific law, but I'll give you the U.S. standards, okay? So here's what the U.S. law says. Harassment is unlawful where either one, in enduring the offensive conduct is a condition of continued employment, or two, the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. So let's cover what that does and does not mean. So if it is actually a contractual part of your agreement, like you have to suffer this harassment, then that would be enough. But in the alternative, which almost never pops up, by the way, I can't think of any case off the top of my head where that's popped up. But the other provision, if it's severe or pervasive enough that a reasonable person would think that it prevents them from, that the workplace is intimidating, hostile, or offensive. Now, It has to be severe or pervasive. So the idea here is that it's not limited to the one-offs. It's to be sexual harassment, it either has to be sufficiently bad unto itself or enough in time. The idea, at least in principle, is that, even crude jokes, even sexual, even like people trying to date other people in the workplace, which may or may not be advisable, may not be enough. If they tell you to stop and you don't, that might be a problem. But, it's not meant to deal with something that is minor. It's meant to deal with something that's severe. And the other thing that has to be factored into this is when you're thinking about a reasonable person, you have to think about a reasonable person in the environment, in the profession at hand, because not all professions are equal. And just to point out the obvious, if you are, say, a cashier at a CVS versus a dancer at an exotic club, those environments are not the same. And the nature of what would be expected in those environments is not the same. And what a reasonable person would expect in those environments are not the same. So it could very well be the case that the type of employment would influence this analysis in terms of what would someone expect in this kind of workplace. So I don't think it's even across the board. So I think those are some important factors to consider when we're going into this as we try to analyze whether or not we have severe or pervasive harassment in this particular context, in the view of a reasonable person. So hopefully all that predicate was helpful to understanding that. All right, so JLM forced Hailey to endure a workplace of fear, harassment, and inappropriate behavior. JLM has fostered and acquiesced to an environment where its CEO, Murphy, has had multiple sexual and inappropriate relationships with subordinates, made scores of sexually inappropriate comments, and engaged in sexual harassment of others. What he's done with respect to others doesn't necessarily have any influence with respect to you. It will only have influence with respect to you in so much as it would impact you directly. And, so they may have a complaint or not, but not necessarily you. You have to actually be injured, right? Murphy's history of unwanted behavior and treatment of women who did not yield to his advances is not a secret at JLM, and Hailey was aware of it. At JLM, employees who engaged in extremely personal or sexual relationships with Murphy were treated more favorably and given special treatment, such as not having to come in the office during work hours, than those employees who did not. Hailey was no exception. Murphy ogled at her private parts, said lewd things to her, and otherwise engaged in numerous inappropriate conversations with and inappropriate behavior towards Hailey. As one example, with full knowledge of implicit threat of this behavior, Murphy would often summon Hailey to a cramped, secluded back office, use his physically imposing nature to block the door, and engage in inappropriate and invasive personal conversations into Hailey's romantic life, sex life, and family life. The threat and toll on Hailey's mental well-being was so severe that she began carrying a sharp object, a seam ripper or X-Acto knife, whenever some of these meetings in case she needed to defend herself. The result of this environment has taken a toll on Hailey mentally and physically. She's experienced hair loss, circulation issues, trouble sleeping, and sought therapy as a direct result of her work environment. The frequency and tenor of the harassing actions only increased over the past year as it became clear that Hailey would not agree to social media responsibilities in connection with her new agreement. Then, after filing this lawsuit and seeking a temporary restraining order against Hailey while still employed at JLM, JLM embarked on a campaign to defame Hailey by spreading malicious lies in the press. Well, if you really think they're guilty of defamation, then, bring a defamation cause of action, and maybe you will. But, that's something we can deal with on its own terms, right? This was designed to create negotiating leverage over Hailey and dissuade other bridal studios, such as Monshare, from hiring her. In addition to subjecting Hailey to a sexually hostile workplace, JLM failed to pay compensation she was owed, which is, again, a different issue. That's a breach of contract issue, so we can deal with that onto its own terms. All right, let's go over some facts that would help us support these rather broad, overarching conclusions and try to see whether or not it's supported based on some facts. After graduating from Cornell in 2007 with a degree in fiber science and apparel design, Hailey began working as an apparel designer for Priscilla of Boston, eventually taking over as lead designer in 2011. From 2007 to 2011, Hailey also worked as a freelancing style assistant, where she began working with high-profile individuals including celebrities like Pharrell Williams, Kesha, and Tina Taylor. Hailey also co-founded a revolutionary bridal gown rental company and started a fashion blog. Since graduating from Cornell, every job she's had has been in the wedding or fashion industry. Hailey was an early adopter of social media. In 2004, she opened a personal account under the name of Hailey Paige, which uses the URL Miss Hailey Paige, a term of endearment by her mother. Over the years, Hailey opened other social media accounts using Hailey Paige or Miss Hailey Paige, including Twitter, LinkedIn, Pinterest, Instagram, Snapchat, Spotify, and TikTok. Like millions of others, Hailey opened the accounts for her own personal reasons. In April of 2012, on a recommendation of a friend, Hailey opened an Instagram with the handle Miss Hailey Paige as a personal account. Hailey's first posts to her Instagram were highly personal and included inspirational quotes, a photo of Hailey's apartment, and a picture of her best friend. Hailey's Instagram has maintained this personal character and authentically revealed her life, family, adventures, and work. Hailey has used her Instagram to share some of her most personal life experience, including posts about her childhood and family, a tribute to her mother and to her father. On July 13th of 2011, at 25 years old, Hailey signed an employment agreement with JLM. JLM employed Hailey as a designer of lines of bride and bridesmaid dresses. On August 1st of 2014, she signed an amendment. The agreements were both drafted by JLM. Drafted by, yes, but, how are they edited and how were they, the initial draft, yeah. So the 2011 agreement provided that Hailey grants the company the exclusive worldwide rights and license to use her name, Hailey Paige, Hailey Paige Gutman, Hailey Gutman, Hailey Paige, or any derivative thereof, in connection with design, manufacture, marketing, and or sale of bridal clothing, bridal accessories, and related bridal or wedding items, including any and all goodwill associated therewith. That's potentially very broad language. So they have the right to her name in so much as it relates to design, manufacture, marketing, or sale of bridal and wedding related items, and all the goodwill therein. So there's that. The 2011 agreement also provides that Hailey assigns her interest to JLM during the term and any extensions thereafter, and for a 2-year period, to register any names. Thus, the employment agreement sets forth, to the extent JLM has any rights in her name, these are limited in scope and time. Not the trademark rights, incidentally, they go beyond that. Namely, those rights apply only to the design, manufacture, marketing, and or sale of bridal clothing, bridal accessories, and related bridal items. Hailey has substantially participated in the designing of those clothing during her employment. On August 1st of 2011, Hailey began working at JLM as head designer for Blush by Jim Halem collection. The first Hailey Paige collection launched in 2011. During her employment with JLM, Hailey served as head designer for the following collections and products. And then they list a whole bunch of stuff. During Hailey's employment with designers JLM, she regularly participated in assisting with advertising activities typical of a wedding designer. She designed and directed the execution of a lookbook and ad campaign for each of her collections, creatively directed runway shows, consistently attended trunk shows, and participated in interviews. In general, including at JLM, social media direction and content creation is a separate job title and not a requirement for industry designers. I'm sure that's typically true, that they have people whose job is that full-time. All right, so then the employment agreement talks about these increases. JLM has failed to pay these increases. JLM failed to pay Hailey the annual increase in base compensation. Hailey also repeatedly failed to pay Hailey the proper amount of base compensation. Well, that's pretty easy enough. I mean, we'll get payment records. They'll get payment records, and we'll see whether or not they did or did not pay them according to the terms of the contract, right? So that's not going to be really factually ambiguous. We're going to see how the contract says to pay. We'll look at what they did pay. We'll see if the two numbers are the same, So fair enough. Since we don't have the exact language of the contract with respect to payments, and we certainly don't have all the payment slips, we can't adjudicate that for ourselves, but should be fairly easy to adjudicate in the end. And then they talk about additional compensation when not being paid in terms of annual sales and collections. Yeah, okay. That's, again, just straight up breach of contract issues. JLM failed to properly account for compensation. According to their agreement, they have two separate provisions pursuant to which Hailey is entitled to receive information. According to the agreement, the employee shall have the right on an annual basis to receive a schedule detailing the sales information the company relies on in making payments of additional compensation. So they get to see those numbers. Unaudited summaries and sales estimates will periodically be made available, as may be reasonably requested by the designer, as to orders for collections that designer is responsible for. Designers shall be entitled to meet with the company's financial officer at the end of the fiscal year for a comprehensive breakdown. The employment agreement further imposes an obligation on JLM to compute net sales. Net sales shall be computed separately for each fiscal year. Such computation may be made as soon as practical. Okay. JLM has repeatedly failed to compute these sales, has repeatedly made requests for a financial agreement, repeatedly failed. So whether or not that's true should be provable in fact if she made requests and whether or not those requests were honored. The sales director for several product lines designed by Hailey was instructed by JLM to conceal financial information sales figure in a concerted effort. Again, that should be relatively easy to prove. She could testify to that or not. Maybe there's writings about it, and what was the nature of the concealment? JLM fails to properly pay commission and ambassador fee. So some more fees, some royalties in this amount, some more royalties. So again, just a standard breach of contract payment thing. No muss, no fuss. Let's just get the payment records. Let's get the financial records. Let's do some math. Should be relatively easy, all things considered. All right, so now we're going to deal with the JLM hostile work environment stuff, which is much more interesting because it's more ambiguous, right? Because this other stuff is just more, what are the facts? The facts are fairly unambiguous. The contract calls for these payments under these kinds of terms. It calls for her ability to get some stuff. She either did or did not make those requests. Those would be provable by emails or other written documents. The company either did or did not respond. That would be provable by emails or other documents. She is entitled to payment. We can just do the math, right? We can just look at the payment records, look at the sales records. We can do the math. Shouldn't be that complicated in the end to figure out who's right on this, right? There's not a lot of ambiguity at the end. So it's not he said, she said. So when it comes to sexual harassment, much more so. JLM CEO Joe Murphy created a culture where work was secondary to his own personal interests. Murphy sought to control subordinate female employees, often engaged in inappropriate relationships with them. These women, always much younger than Murphy and usually blonde, who capitulated to Murphy's advances, obtained preferential treatment at JLM. Although Hailey did receive some perks because she generated so much revenue, Hailey did not receive the same preferential treatment because she did not engage in a relationship. Okay? Which is one of the reasons that sexual relationships between subordinates and superiors is ill-advised, because then you run into these problems, right? Because then you have to untangle it. Like, is the reason that the supervisor treated someone more favorably or not due to these favors, these sexual favors? And if so, were they a quid pro quo, or was it understood that way? Or was it because of completely innocuous reasons? It's a little hard to untangle that. So that's one of the reasons that a lot of companies try to dissuade that, because it's hard to figure that out on the back end. What was the real reasons behind stuff? Upon information belief, Murphy has engaged in inappropriate workplace relationships with at least 3 women who were subordinates. Murphy followed a child with an employee while married to another woman. I'd like to point out that, at least as far as U.S. law is concerned, it's not inherently inappropriate, right? Because the way those sexual harassment guidelines read, right, it would only be a problem if it would be to a reasonable person, and it's severe and pervasive. So if you did something that was non-severe and non-pervasive, and they liked it, and you did more, and they still liked it, then there's no problem, because there's no harassment, right? It would only be a problem once they said no and you kept going, or you did something so bad that no reasonable person should be expected to receive it right off the line. But I don't think it's inherently inappropriate, although maybe ill-advised, for him to have relationships with people in his company. So I'm not sure why she's reaching that conclusion necessarily. Now, it would be a problem if he's treating those people professionally different as a result. That would be a problem, but I don't think it's a problem inherently. Okay, most recently, Murphy was engaged in a relationship with JLM employee who we're going to name by name, which seems like a very dick move to me. Like, we're going to actually call out this other woman in public for being associated. Why did we do that? I don't know. Murphy's relationship with this person was now well known among JLM employees and bridal store owners. This person accompanied Murphy to industry events, including Hailey's wedding, where they shared a hotel room. This person's work role was never clearly defined to JLM employees, but because of her relationship, she received special treatment. She was permitted to come into the office when she pleased, would not be criticized for poor performance. Murphy would often compliment his girlfriend in front of others, including Hailey, even though whatever work she did was subpar. I mean, how would you know that? How do you know whether her work was subpar? Because you don't even know what her work is. This sent a clear message to Hailey and her colleagues that a relationship with Murphy would result in praise and protection in the workplace. To underscore this message, Murphy kept a prominent photograph of his girlfriend in his fifth-floor secluded back office, which Hailey and others would see when talking to Murphy. Yeah, it's not exactly great behavior. I know about the photograph. I'm not sure. That's not great. It's wonderful for sexual harassment lawyers, but it's not advisable. Like his girlfriend, apparently, it's known other employees who engage in these relationships might have been given extremely preferential treatment by JLM and Murphy. She's just referring to like innuendo and sort of like gossip, basically. She seems to be alluding. She doesn't know what is in other people's minds. She can't. And she's like, well, this is just generally known. How does she know that, really, right? If she knows it from specific ways, it's not being made clear. Some of these employees were permitted to work whatever hours they saw fit and were immune to criticism. Murphy created a toxic work culture when it became clear that employees who engaged in relationships with him were treated differently than those who did not. Murphy also made direct, inappropriate, unwanted advances to another female employee. Okay, well, she might have a complaint. Right? This employee resisted Murphy's advances and then required therapy to process the incident, which may or may not be proportionate depending on what we're talking about. How did he make the advances? What was the nature of them? Were they within the bounds or not? Right? After this incident, Murphy also spoke negatively of the employee's boyfriend to Hailey. Upon information belief, Murphy indeed intended to demean and insert himself between female employees and their partners when Murphy desired a relationship with the employee. After a particular employee rejected Murphy's unwanted advances, Murphy also began commenting negatively on her performance. For example, a text message to Hailey, Murphy stated that she is put together psychologically and needs to be micromanaged, and that she can't delegate, has no aptitude, cannot keep track of time, nor multitask. Which I don't know the degree to which that's true, or the degree to which it's an unfair characterization, or the degree to which it's only being mentioned because of the relationships. When this is what happens when you have relationships in the workplace, things get messy, and trying to untangle the mess can get really problematic. So most corporations just simply say, don't do it at all, just because it's simpler. It's simpler. It's not necessarily legally required, but it's simpler. It's like if we just say that no one can have relationships with anyone else, then, or we prevent it between subordinates and superiors, then we don't have to worry about these problems of unequal treatment and stuff. So, there's reasons for practicality. A lot of corporations have tighter sexual harassment guidelines than the law requires because it's just more convenient for them. When a corporation does something they don't have to, obviously it's for their benefit. So if they're going to have tighter sexual harassment guidelines, it's because, well, it's just easier for us not to deal with this and untangle everything. So that's some of the reason behind that. Throughout the last 5 to 7 years and going back to 2014, Murphy repeatedly made sexually provocative comments to Hailey. Some examples are, in 2014 at a bridal market in JLM, Murphy lewdly told Hailey, who was wearing red pants, that she had camel toe, meaning he was able to see the contours of her genitals. Maybe he's trying to just tell you that you had a problem you weren't aware of, and he was alerting you to it. I don't know if it's necessarily a lewd comment. You'd have to know more. I mean, maybe it's the equivalent of a guy's fly being open. I don't know. On April 15th of 2019, Murphy told Hailey she looked pregnant. On October 21st, which isn't advisable, incidentally. Just don't do that ever. On October 21st, Murphy said she looked real cute at a JLM store in Los Angeles. In February of 2018, Murphy told Hailey, who was wearing a pink shirt, "You look washed out, wide and down market." Okay, well, maybe that's a fair assessment. I mean, he is a fashion designer, and maybe he's like, that shirt's not working for you fashionally. I mean, he's obviously interested in fashion. The entire company's named after him. So he's obviously interested in fashion. So it wouldn't be surprising that he might comment on other people's fashion. And that certainly wouldn't necessarily be sexually harassing. It wouldn't necessarily harassing because he's a fashion designer. And fashion designers also can be a bit prima donna. So there's that too. So, it's not necessarily obvious that it's a problem, this being said. But then again, we're trying to analyze this in the entire context, and it's kind of hard. That's one of the reasons juries get so much time to consider stuff. In January 3rd of 2018 in Nashville, Murphy told Hailey, who was wearing a black lace outfit, she looked sexy. In October 2019, Murphy looked Hailey up and down. If she wears a piece of meat, you look spectacular and really slimmed down. I mean, he's a fashion designer. He's looking up and down to see the fashion you're wearing. It's not inherently obvious, right? Because, it's a fashion design company. He runs the company. It's named after him. It's literally his initials. There's a reason it's called JLM. It's named after him. And he's the head of this company that does fashion design. He probably spends a lot of time thinking about fashion design and how clothes look on people. And it would not necessarily be unexpected for him to comment on how people look. Even fellow employees, particularly to the extent that they are somewhat faces of the company. And what they wear might project a look for the company. I mean, it wouldn't be absurd for him to comment on it. Upon seeing Hailey on the Knot magazine cover, told her she looked sexy, fun, and fresh. When making these comments, Murphy would often ogle and stare at Hailey's breasts and legs, which he often commented Hailey were strong gymnastic legs while looking up and down her body. Yeah. He even took Hailey clothes shopping at BCBG and J. Crew and insisted she try on clothes while they look them on. Okay, I mean, is that inherently absurd or not? I don't know. I mean, this isn't a model, so there's that. It's a woman who's a bridal designer, so it's a bit inappropriate in that way. And also, J. Crew is probably not a competitor for JLM, but that being the case, however, he might be interested in what, different fashion houses of different levels are doing. Again, he probably thinks about fashion all the time. I couldn't swear to it, but I would imagine that someone who's really, really interested in fashion, to the extent they have an entire corporation named after them, might be interested in fashion of all types, on many different price levels and different designs. And so he might be interested in seeing what people who go to J. Crew are wearing. Maybe he can learn something that would help him in his design. He can be inspired by it in some way. I don't know. Or maybe he just thinks it's interesting. And whether or not it's appropriate to ask her in particular is a whole other set of problems. But again, he's a fashion designer, so it's not inherently absurd, it seems to me. Murphy also made a sexually inappropriate comment to or about other female employees. As one example, Murphy commented on intern's class and said, "I didn't know it was wet t-shirt day." Which, if her t-shirt was wet at the time, is a bit of a snarky comment. Murphy frequently got inappropriately close to Hailey at work, and various events would put his arm around her. Okay, that's okay. Well, again, they're at events, so I'm going to interpret this as work events, close to work and various events. Now, although it's not said, I'm going to interpret work events. And so he put her arm around her. How did he put his arm around her? Do you mean around her waist? Do you mean around her shoulder? Was he touching inappropriate parts of her? I mean, is it inappropriate to put, maybe they were posing together for a photograph, or how was this being done? Was it being done because they were posed for a photograph, or was it being done just like when they're not being posing? So that would definitely be more suggestive of sexual harassment. What exactly is going on here? Before Hailey was married, Murphy would frequently invite Hailey to his Florida home, Further, we can imply this would be getaway for pleasure, as opposed to business. She laughed off these inappropriate invitations, which is absolutely her right, and she had every reason to say stop if she wanted to. So I don't know what laugh off means exactly, but if he was continuing to make approaches when she was laughing him off, that might be sexual harassment. That might be pervasive conduct. Because he did not relent to the pressure, Murphy would put Hailey down, condemn her, and compare her to his girlfriend. He repeatedly told her design work had gotten worse. She hit her peak in 2018, and like Muhammad Ali, she got caught admiring her own work and was going to get caught knocked down. She suggested Hailey should be more like his girlfriend, saying, Lana has that Russian charm most women don't have. Not to put too fine a point on it, but Russians are not particularly known for their charm. You should really hang out with her a lot more often. She has a lot more to offer. Murphy has also commented to Hailey that his girlfriend's physical attractive made her intimidating to other women. Maybe it does. I don't know. Murphy felt uncomfortable listening to these comments on attractiveness of another employee. And she expressed that would be more of a problem, right? Despite being a publicly traded company, during Hailey's employment, JLM did not have a qualified human resources officer or department. They're not required to by any law I'm aware of. As the largest shareholder, JLM is essentially Murphy's company. Yeah, it's a publicly traded company, but it's named after him, and he's the largest shareholder. So it's his company. Yeah. All personnel decisions were driven by Murphy, even though he's the biggest offender. Yeah, it's his company. He owns the shares of the company. He's invested in the company. Okay. I mean, yeah. Murphy's man cave, which has a special provocative photograph of his pet employee, his girlfriend. I like how we keep mentioning his girlfriend by name, just continually throwing this person under the bus. That is just so, low rent or something. It's like, you're calling out this other woman, keep mentioning her by name. It's like, look at you, calling her out. I mean, are we just going to use the SLUT word at some point? Because we're basically alluding to it at every point. It's like, this is just... what is the point of this? Bringing this other employee and just throwing them so deep under the bus, Anyways, in his man cave, he had special provocative photographs of his pet employee, was secluded and only accessible by going through several offices. Okay, so it's not an open display. That's good. Space was a little larger than the closet. It was where he would meet with Hailey alone, with other female employees, and question them about personal lives or romantic relationships. Murphy would keep the air conditioning blasting cold in the small place, and Murphy also sat closest to the door. Hailey would be forced to sit on a folding chair directly next to Murphy, who controlled entrance and exit as the only person to open and close the door. The effect was that Murphy, who had physically imposing compared to Hailey, made Hailey feel trapped. This, combined with Hailey's awareness of sexual relationship with other employees and unwanted harassing behavior toward her, led Hailey to hide sharp objects in her pants in case she needed to physically defend herself. During these meetings, Murphy often steered the conversation to inappropriate personal topics. Hailey was fearful not to engage on a personal level with Murphy, but he groomed her to divulge personal information in fear of what happened if she might refuse to do so. I don't know about grooming or not, but yeah. During one such meeting, after Hailey told Murphy her then husband had health issues, Murphy told Hailey he would never be able to satisfy her in her marriage. Ouch. That doesn't seem like an appropriate comment. That seems very inappropriate as a comment to me. In other man cave meetings, Murphy pushed Hailey to talk about romantic life, and upon getting her talk, repeatedly told her she was losing focus and distracted by her fiancé. Murphy told Hailey her relationship with her fiancé is really not good for you because of a distraction from work. Well, that's kind of inappropriate. Murphy made clear he did not approve of the fiancé, making Hailey feel she had to agree with Murphy and comply with his wishes to remain in good graces. Okay, that's definitely more suggestive of a toxic atmosphere, if that's true. Further, with what amount to hostile work environment when a young, sexy woman was hired, groomed, and solicited, Murphy, in private meetings, repeatedly told Hailey not to have family and children, often spoke negatively about employees with children, and suggested they're performing poorly because of familial status. That's not great. For example, during one meeting with Hailey, Murphy stated that female employee A, which we're not going to mention by name for some reason, so we'll keep this employee's name anonymous, although we're going to mention the girlfriend's name at every possible opportunity, but this employee will keep secret. Female employee A is constantly distracted by her kids. She can't possibly get the job done working as a mom from home. Murphy also said the kids are a distraction. Look at female employee B. She's too busy having babies to be interested in advancing. Mithrin Emrys asks, so apparently we've reached the throw it all against the wall and see what sticks portion of the lawsuit. Didn't this begin over ownership of her name and Twitter account? It sure did. But now we've gone from a fairly simple contract dispute issue with, fairly clean issues and get the evidence in and, should be fairly clean resolution. So we've gone from that to Hailey now bringing in sexual harassment as a counterclaim. So she's arguing that she wants to sue them for the sexual harassment she had to endure. She wants to bring that into the fold, which, you can't help being a little bit skeptical too, because, it's such, the problem with the sexual harassment claim is that they're so ambiguous inherently. They're tough because it's difficult to show what you need to show because different people's perceptions and what's happening and stuff. So, sexual harassment claims are difficult. And why are we necessarily bringing that up now? And did she ever bring it up before? And if so, how? It leads you to thinking that maybe, something's wrong here. It might not be. Maybe everything she says is true. But I'm a bit skeptical because we moved from a fairly clean issue to a fairly ambiguous issue, and also even more troubling, we're dragging this one female employee through the absolute mud, even more so than him, to be quite honest. I mean, I think her name made more appearances than his name. It's like this one employee who I'm definitely going to mention by name every 5 seconds, who is, I'm not going to say it, but she's trading her body for advantage, so she's selling herself. So I'm not going to say that, but I'm going to say it. But yeah, it's really disturbing. And that's the fact that she kept throwing her under the bus left a bad taste in my mouth. Because she didn't have to mention him. She mentioned the other female employees by female employee A, female employee B. Why not mention her by just female employee? Give initials or something. But it seems so off point. Mithrin Emrys says, speculation. She brought the sexual harassment claims to force them into making accommodations during arbitration. Even if they can disprove her claims, it doesn't play well in the media. Yeah. I think that's a significant factor. The media war here is real. The free Hailey Paige thing is real. And now her throwing sexual harassment into it, makes you think, I'm going to be a little bit skeptical of these claims. I'm going to be skeptical of these claims. I'm going to be skeptical of it and what's really going on here. And why are you dragging this one female employee completely under the bus every 5 seconds? Why are you doing that? Something doesn't feel right about it. It might all be true. Maybe it'll all be true, proven at trial, but something doesn't feel right about it. And the timing of bringing it, it's a little bit, Why in this section, why in paragraph 92, do we call them female employee A and female employee B? And we couldn't mention the other employee's name enough. What is all that about? Hailey loved designing dresses and often justified the hostile environment as the price for doing the job she wanted. She often appeared agreeable or overly positive in interactions with Murphy, even when she disagreed with him, simply because it's easier to be compliant than subject herself to harassment. However, as a result of working under Murphy for years, Hailey's seen adverse effects on her mental and physical health, as well as her personal relationships. Hailey has experienced hair loss, circulation issues, trouble sleeping, and sought therapy, which presumably is documentable. In recent years, when began calling to a meeting with Murphy in the same room, Hailey would begin physically shaking. Hailey became terrified of these meetings and often counteracted fear with agreeability, with the belief that any resistance would prolong the uncomfortable experience. JLM work environment and Murphy's behavior ultimately became too much to bear and so intolerable that she was forced to resign for JLM. Well, that doesn't appear to be correct. She didn't resign because of that. She resigned because of the contract negotiations. The contract is being negotiated and they can't come to agreeable terms, and so she resigns. It doesn't appear to be because of the harassment. It appears to be because the new contract negotiations didn't go through, which is a perfectly valid reason to leave, right? We weren't able to reach an agreement. You know, Azeroth, I had never noticed that before. I don't know why, but you're absolutely correct. I had never noticed that before ever. Yeah, hashtag me too could be read as pound me too. I never thought about that. You get a bonus point. In July 2019, Murphy sent Hailey a proposed employment agreement, sought to impose even new duties and responsibilities, and expand JLM's rights even further. The proposal included a list of promotional responsibilities. Okay. Would require her to participate in creating promotional content for the company. It became clear that JLM and Murphy wished to impose new responsibilities relating to Instagram and social media that were beyond her scope of her responsibilities. Yes, they wanted to increase your responsibilities. Hailey responded the proposal was unacceptable and sought to clarify the party's position with respect to the Hailey Paige name. On September the 15th of 2019, Murphy responded that as far as your personal investment regarding JLM, it's really only related to Hailey Paige wedding gowns and related categories, but I do not claim your persona beyond that, which is good because neither does the contract. Murphy's statement confirmed Hailey's understanding of the employment agreement that neither Murphy nor JLM intended to claim rights to Hailey's name outside of bridal gowns and other bridal-related products created by Hailey during her employment. That is what the contract calls for, so that's perfectly fine. On or about May of 2020, Murphy began to escalate his demands, despite his prior statements and representations, started making expanded ownership claim over her personal account. And this is where the dispute comes in. How personal is it? This is the first time in that 9 years that JLM expressed any ownership for her account. Maybe it became within the bounds based on your own activities, I couldn't say. I mean, it wasn't a company account at the first instance because I think it was created before you joined the company. But maybe because what you did, you know? Hailey viewed this assertion as going beyond the rights set forth in the employment agreement. Accordingly, on 3rd of June 2020, Hailey responded to Murphy and made clear, I cannot accept you or JLM making a claim on my personal Instagram account and general persona. Despite Murphy's assertion, in October, JLM increased pressure on Hailey to enter into the proposal and relinquish additional rights. JLM had its lawyer send a threatening letter to its employee Hailey. JLM threatened that Ms. Gutman has failed to agree to reasonable terms and may not recognize the importance of concluding the matter. I mean, that doesn't sound particularly threatening to me. She hasn't agreed to terms we think are reasonable, and she may not recognize the importance of it because it would mean the ending of our relationship, but, okay. We have a low standard for threatening. JLM's attacks increased during confrontation instituted by Murphy and in-person, because here's the thing. If it's a threat, what is the threat? What is the threat? And is it a legal threat or an illegal threat? What exactly do you think why do you think it's threatening? What is the threat? What do you think that their lawyers are alluding to? It's like, well, we can't agree to reasonable terms, and you may not recognize that if we can't agree to reasonable terms, it means that we can't go forward, which maybe you don't, because, the company wants this, right? The company wants this, so maybe you don't recognize, because maybe it hasn't occurred to you, that if we can't agree, that we're going to be done. So what's the threat? It's not apparent. JLM's attacks increased during a confrontation instituted by Murphy at an in-person event. Hailey attended a bridal trunk show in Kleinfeld Bridal in New York. Hailey was so nervous to meet with Murphy, she had to take anti-anxiety medication to calm down. During the trunk show, Murphy was condescending, stating that Hailey needed him to be successful. Murphy also suggested that he had a lot of money to fight Hailey. Well, that much seems to be true. It seems to be a fairly profitable company. On December the 15th of 2020, while Hailey was still employed, JLM filed a complaint against and sought a TRO for authorizing the parties' names. Thus, the TRO sought by JLM was one piece in Murphy's deliberate effort to impose him on Hailey's life, both business and personal, and attempt to exert control over Hailey. Well, it's an attempt to gain control of company assets. By the TRO, Murphy gained control over Hailey's ability to speak out on her own name. Okay. I'll keep explaining this till it gets boring, but she can't use her name in trade. If she's using her name on these accounts to speak to wedding design dresses, particularly ones she had a hand in creating with, then she has mixed business with personal, and now we have to untangle that, and that's going to be a huge mess. But there's nothing stopping her from creating a new account and calling it Miss Hailey Paige Personal and commenting all she wants about things that she just can't talk about. She just can't, put pictures of bridal dresses she helped create and, and talk about that stuff. So she can talk about her stuff under her own name. I don't know. Upon information belief, JLM acted deliberately and intended the escalation of these baseless threats. Murphy's threatening improper comments and filing of baseless lawsuit. It can't be that baseless. I mean, the judge did grant the TRO and the preliminary injunction, so the judge thought there was some merit to it. Though through this forced resignation, no. JLM sought to gain through legal system what it could not gain through negotiation: the rights to the media accounts, name, and ability to earn a living. Well, that might be on you because, again, JLM has the rights to your name to the extent that they relate to designs of bridal dresses that you participated in. And so if you posted pictures of these bridal dresses and commented on them on your personal accounts, now they fall within the domain because it also contains other stuff, but it contains the stuff the company is entitled to. And so now we have to untangle this mess. So that's a lot of fun. But, yeah, okay. Due to the intolerable nature of Hailey's working environment, the constant threats, Murphy's inappropriate excuse of control of Hailey. Therefore, Hailey resigned. Okay. All right, so... All right, okay. On December the 21st of 2020, Hailey's counsel wrote to JLM counsel and stated, Ms. Gutman does not consent to JLM Couture's use of her photographs, portrait, image, voice, or likeness. Despite the explicit demand that JLM not use Hailey's photograph, portrait, or likeness, JLM proceeded to do exactly that. In particular, using the account with the handle, Miss Hailey Paige, JLM made a commercial feed post and posted Instagram stories using photograph of Hailey. When JLM began posting its own content selling bridal wear on Hailey's Instagram, JLM did not make any mention or announcement it was no longer Hailey using the account, or Hailey had resigned, which they're under no obligation to do. To date, JLM has made more than 65 posts advertising its products and many additional stories without any mention that Hailey is no longer in control and no longer associated. They don't have to. It's their account, as long as they're using it with bridal dresses she helped design. So, JLM has also failed to take down thousands of personal photographs. Okay, but you're the one who posted them there. So you obviously consented to them being there in the first place, and, and you've mixed business with pleasure, and now we have to untangle that. It's a mess. Thousands of photographs and posts do not belong to JLM, and individuals in the photographs have not given JLM permission to use their likeness and images. Sure they did, because you posted them. So, yeah. JLM's deception, aimed at Hailey's Instagram, is intended to deceive that Hailey is still in control. Hailey is an influencer, and her posts are highly valuable, which has zero impact on anything legally. Okay, so let's talk about defamation. Let's see if we can get some defamation cause of action in this thing. See if we can improve this at all. Hailey was constructively discharged from JLM. JLM began mounting a public campaign to damage her prospects. JLM has knowingly made a false statement with the intent to disparage. Okay, what would that be? On December 24th of 2020, JLM notified Hailey's counsel because JLM asserted that was locked out of the account. JLM's counsel stated last night, someone, we presume Ms. Gutman, changed the associated account and phone number. Okay, so their counsel contacted your counsel, which is effectively the same thing as contacting you incidentally, but you're represented. So they can't. They literally can't. They can't contact you directly. It's illegal. But your lawyer is your representative. So it's effectively the same as them contacting you. And JLM's lawyer said, hey, Hailey Paige's lawyer, we seem to be locked out of the account. Someone, and we presume it was Gutman, did this. Can you help us? So is that defamation? No. Why? Well, because it's not communication to another. The attorney doesn't count as another in this equation. For this purposes of this exercise, the attorney is Hailey. Because the attorneys literally can't, because the attorneys, they want to communicate through legal counsel, which is a really good idea. Really good idea, legal counsel communicating through each other. Now, a lawyer cannot communicate with the other side's client. Deep thoughts, right? The clients can talk to each other, although the attorneys would really prefer that they don't. The clients can talk to each other, but if the attorneys are trying to talk to each other, they can't talk to the other client. So my only option is to communicate to their side. It's attorney. So it's not defamation. So for this purpose, I'm not communicating to another. I'm communicating to you. Within 2 hours of receiving this message, Hailey's counsel responded that Hailey's not changed anything with respect to the account. Okay, great. We deny it. Matt stated JLM is currently locked out of the account and does not have access. Counsel reiterated Hailey did not change anything on the account, but offered to help JLM unlock the account if JLM had locked herself out. JLM did manage to unlock the account with the help of Hailey's counsel on Christmas Eve. Great. Great. Problem resolved. Problem resolved. The TRO clearly gives the asset to the company. You know, we may not be happy about it, but that's the state of the law at the moment. They seem to be locked out of the account. We think maybe it was Hailey Paige. We deny that we did it, but we can help you. And we can restore the status quo. Status quo restored. Everyone's happy. Okay? Yeah. Despite this background, JLM claimed an email to Insider, which would be different. That would be to another. JLM claimed an email to Insider that Hailey locked JLM out of the account by changing the lock word and password. Okay. Specifically, Insider reported that. Okay. A JLM spokesman told Insider that Gutman changed login information on the Miss Hailey Paige Instagram account after a court order which required her to hand over the account. Okay. Now you're better off. You're talking to another. Great. Hailey again hijacked the account with changing once again login password and refused to share those with JLM. The spokesman told Insider at the time. Now, I have a question. When did this conversation happen in context with the other things? Right. So was that a negligent statement at the time or, you know, in addition to being knowingly false, well, was it knowingly false at the time they communicated to Insider? They say, despite this background, JLM claimed an email to Insider. Well, when did the email occur and when did this conversation, did it occur before or after Christmas Eve or on Christmas Eve? The thing published, it looks like 2021, which I'm assuming is the first day of 2021, January the 1st, I guess. And apparently this was all resolved on Christmas Eve. So is it possible that this was communication happened or they didn't know or something? I mean, you know, who made these statements? You know, as a JLM spokesman, okay. In addition to being knowingly false, the statement carries an accusation that Hailey has violated the order. JLM spokesman explicitly stated that it was an apparent violation. JLM has made no attempt to correct. Okay, I'm not sure about knowingly false, but it might be negligent. It might, well, and we have a couple questions in our mind. Does Hailey Paige qualify as a public figure? I think the answer has to be yes. I mean, she's very purposely injected herself into the media space. I mean, she has 1 million+ Instagram followers, don't you know? So I think she's got to be a somewhat public figure. So are we under a limited purpose public figure analysis? Probably. So then we need either knowingly false or reckless disregard. Was it knowingly false? I don't know. It depends who's making it. If they knew, you know, what they were saying. So, I don't know. But you might be able to get there. You might be able to get there on a defamation cause of action. At least it's plausible. The employment agreement is terminated. Hailey, through her counsel, sent a letter to JLM terminating the employment agreement. JLM has materially breached the agreement. Hailey also notified JLM it no longer retains any benefits to the employment agreement, and JLM is no longer authorized to manufacture or promote any products bearing trademarks or design name. That cannot possibly be true. JLM is not authorized to manufacture, cause to be manufactured, sell, market, otherwise distribute, or promote any products bearing the trademarks or design name, Hailey's photograph, signature, likeness, or image. I'm not sure about that one. The trademarks for sure can't be right. The designer's name can't be right because that they get the trademarks perpetually. No. The photograph, signature, image, likeness, you might have better, but the name, no, not given the contract we know. So failure to pay wages, failure to comply with an audit obligation, that presumably is the failure to give me the accounting information. We want an actual accounting, breach of contract, constructive discharge, breach of contract, failure to pay wages, unjust enrichment from whatever, conversion. No, you can't get to conversion. That doesn't even no, you can't get to conversion. JLM has improperly exercised domain and control over the accounts to the exclusion of Hailey on the basis of various misrepresentations to the court. Really? You're going to try to get to conversion? You're going to try to argue that what they told the court was so deceptive that it misled the court, and so they've effectively converted through a legal process? Good luck on that one. Violations of the Stored Communications Act? No. Violations of New York civil rights law for sexual harassment? Doubtful. False advertising and Lanham Act? No, they have the trademarks. JLM does not consent to JLM's use of the trademarks. Yes, you did. I saw it in the agreement. Those are those trademarks, perpetually. The way I read it, at least. No. Violation of New York's GBL. What is GBL? As described above, JLM's posts on Hailey's Instagram account amount to consumer-oriented conduct. They're materially misleading in that they communicate to consumers Hailey's posting. No, they don't continue to communicate that. In fact, your exact point was they never said anything about it. No. Unjust enrichment? No. Defamation against JLM? Maybe. Discrimination violation against NYSHRL? Discrimination on the basis of gender and sex? Maybe. Discrimination violation? Maybe. Declaratory judgment? Yeah, I mean, either way, the court's going to have to declare the contract. So either way, someone's getting a declaratory judgment. So definitely one of them is going to get that for sure. Declaratory judgment for the names. Again, yes, someone's going to get that judgment for sure. Declaratory judgment in the alternative for an unenforceable non-compete agreement. Well, the non-compete agreement only, I think, extended for 2 years or something. Or I forget exact terms, but yeah, so employee covenants and agrees during the period of her employment with company, employment shall not compete with company. Does not operate as a non-compete provision. She's no longer employed by the company, so yeah, that seems fine. You can get that. Declaratory judgment for trademark. No. The rights should revert back to JLM based on material breach of the agreement and employment discharge. No, those are not valid remedies. Even if they materially breach the employment agreement, and even if it's constructive discharge, you have remedies for that. One of which is not, I get the trademarks back. I don't see that happening. No. So I want declaratory judgment that Hailey's no longer bound by the employment agreement. Sure. Any assignments under the employment agreement are void. No. JLM may no longer reach any benefits. No. Hailey's not restricted to use of designer name. Yes, she is. JLM may no longer use this name. Yes, they can. In connection with goods or services, JLM may only use the designer's name in connection with bridal clothing accessories Hailey has substantially participated in. That's probably more on point to be correct, actually. That's probably more on point to be correct. They can only use the stuff with respect to the stuff she designed. probably true. And they may only extend till December 16th, 2022. I don't know about that one. Though the work she helped design, I don't know about that, man. I think they have those rights perpetually, so I don't know about that part. JLM is restricted in her ability not to work. Yeah, I think she can do whatever she doesn't appear to. JLM does not throw the rights to Miss Hailey Paige for use in social media handle. JLM does not retain any rights in the Hailey Paige formative marks. What is a Hailey Paige formative mark? I don't know. Hailey is the sole and exclusive owner of the Hailey accounts. We're going to have to untangle that nightmare. That should be fun. Enjoying the officers from participation in engaging in further use of the brands? No. Directly using commerce, confusing the slimmer? No. Using a mark, confusing? No. Directing JLM to destroy goods or marketing materials bearing the Hailey Paige name or any confusingly similar name? They have the trademarks? No. Directing JLM to engage in corrective advertising? No. Directing JLM to assign all registrations to the marks to Hailey? No. Directing JLM to perform equitable counting of all sales? Sure. That's fine. I have no problem with that. Yeah, we can go through those records and make sure you got paid appropriately. That's fine. Maybe you didn't get paid appropriately. We can figure that out. Directing JLM to file with the court a written report setting forth the detail in which they've complied? Sure, why not? Awarding damages in the amount to be determined? Fair. Okay. Awarding statutory damages under the Secure Communications Act? No. Punitive damages in a breach of contract claim? No. Exemplary damages? No. Treble damages for what? No. Awarding disgorgement? Oh, I want all the money back. Awarding disgorgement of all amounts received by JLM as a result of these conduct? No. Awarding cost fees? No. Liquidated damages? No. Awarding prejudgment, post-judgment? No. Awarding Hailey such further relief as proper? Yeah, no. And no. So a lot of these claims do not appear to be going anywhere, in my humble legal opinion. Some of them may be viable. The contract claims look the most viable. It looks like, that seems the most viable, that she was not provided with the auditing information. I tend to believe that. It may or may not be true, but I'm willing to believe it. And that they may have had the data from her. So fair enough. So the contract claims, in my view, look like the most plausible. Now, that doesn't necessarily mean that she's entitled to a lot of money or necessarily any money, because maybe they gave her everything she's entitled to. But she can get an accounting for sure. No problem. Yeah, I'm happy to do that if I'm a court. I'm happy to give her an accounting. Let's get all the records. Let's look at them all. Let's do the math and figure out if you were paid properly or not. That's fair enough. You're entitled to be paid, and, let's look at the numbers. Sounds good to me. Maybe the court can appoint an auditor. That'd be good. And they can look at the numbers or something. And JLM can pay for it. That'd be good. The court's going to appoint an auditor. JLM, you pay for it because they're entitled to an auditing. So, and they get to look at the numbers and report back to the court. Looks good to me. So fine. The stuff dealing with the use of the name, no. The trademarks, no, don't see it. The trademarks look like they're perpetual. So no, I don't see that. The signature is more maybe the photographs. Well, they were of her that were taken by JLM. Maybe not, but it's hard to see, yes, because, they were properly taken, and I don't know, I don't see that working. Even if it's like use in production, I don't see that really working. Sexual harassment stuff, who knows? Again, we have to look at this in the proper legal standard. Was it severe or pervasive? And we have to interpret that by the reasonable person, and we have to put ourselves in the proper venue, and it's an entire mess. And also the fact that she kept calling out this one woman by name over and over and over again when she clearly didn't have to, because she knows how to write employee A when she wants to. So for some reason, she kept dragging this one employee under the bus. Why? I understand dragging JLM under the bus. That's fine. He's the guy that you hate, but why drag his girlfriend under the bus repeatedly? What's that all about? What's all that about? It seems so unnecessary. Why are you exposing her? It seems so unnecessary. So I'm doubtful. I'm questioning. But, we can get into it maybe, but I don't know. I don't know if the court really wants to go down that road. If I were the court, I'd be disinclined to go down that road because, I just want to deal with the contract issues. That's fine. And these other issues, maybe I could refer them to some other body, like some sort of consumer protection body or something. It's not for me in the first instance, so you can have that cause of action dismissed without prejudice, file it somewhere else. Maybe it would be the right way to deal with this, but a lot of this stuff looks questionable, so that's what I think about all that. So we'll see. Matova asks, wouldn't the naming rights depend on the contract language? Yes. If in the contract she agreed that GLM can use the name without the restriction, she had to be dissolved. No, the way we read there's a couple different provisions of the contract that are in play, and we can go over it again, but we can go over the exact language of the contract again because it's been a while. So let me find the exact language of the contract and we can pull it up. All right, here we go. Section 10, exclusive right to designer's name. We're definitely not hiding the ball, right? The employee grants the company the exclusive worldwide right and license to use the name Hailey Paige, Hailey Paige Gutman, Hailey Gutman, Hailey Paige, or any derivative thereof in connection with the design, manufacture, marketing, and or sale of bridal clothing, bridal accessories, and related bridal and wedding items, including any and all goodwill associated with it throughout the term, plus a 2-year period following the term or any extension thereof, provided the company has substantially participated in design and clothing during the company. All right, so as to this section, we have the right to use that name for a 2-year period following the term, provided the employee has participated in it. Great. All right, so that section's pretty clear. The employee hereby irrevocably sells, assigns, and transfers all right, title, and interest to the company that now exists or may exist during the term and any extensions thereof, and for a period 2 years after, to register the design name or any derivatives as trademarks or service marks with the USPTO. So they have the right to register. So this is where things get complicated legally, right? So subsection A, we have the right to the name during the period and for 2 years thereafter for the bridal design and that she designed. Then she irrevocably sells, assigns, and transfers all right, title, and interest to the company that may exist, and for a period of 2 years thereafter to register the name or any derivatives thereof with USPTO. And then it says this, except as otherwise provided herein, the permission of the employee to the company to so register the trademarks shall be exclusive and perpetual, which implies that they have the right to the trademarks perpetually. So they only get the trademarks that exist during the contract, so they can't create new marks. But any marks they do create, the way this reads, or the way it's suggested, right? The permission of the company to so register the trademarks shall be exclusive and perpetual, which implies the right to re-register. Implies the right to keep the trademarks indefinitely. So they have this interesting clause in Clause B, where they can only use her name in connection with bridal design for 2 years, and then they also transfer all right title for the company to register any marks, and then to keep them exclusively and perpetually, which implies well beyond the 2 years. This is the most natural reading to me. The trademark shall in perpetuity be the exclusive property of the company. The company, employee having consented to the following, shall have no right to the use of trademarks, design name, or any use of name in commerce during the term or any time thereafter with ready consent of the company. So I don't know, man. That language seems pretty on point to me. So they only have the name, they only have the rights to name for the period and 2 years thereafter. But as to the trademarks, they look unlimited in time. That's the most natural reading of the clause to me. Seems pretty clear. In perpetuity, be the exclusive property of the company. Employees shall have no right to use the trademarks, design, name, or any confusingly similar marks in commerce during the term or any term thereafter. JLM has the better end of it on the trademarks for sure. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.